Mr Chair, that's quite a significant departure. It's a serious issue.
Mr Chair.
Jacinta Ardern.
Mr Chair, and there was quite a lot of interjection from the other side of the House during Sue Moroney's contribution, and I would really welcome Mr Sabin, perhaps the chair of the Select Committee, to stand up and take a call, and if you've got some evidence to refute what Ms Moroney was rightfully querying, I think, using the committee stages, which is what it's intended for, then I would really welcome Mr Sabin doing that. But I have to say, my previous experience of Mr Sabin has been that usually his interventions are often slightly antagonistic. I'm going to be honest. And I think it was probably quite fair of Sue Moroney to instead just say, I'm asking a legitimate question. If you have alternative evidence, I'm happy to clarify our comments previously in Select Committee. I don't think now is the place. Now is not the place, Mr Luteringa, to discuss scabs. This is the debating chamber. Mr Chair, I want to talk about the discretion that's in the bill granted to the Commissioner around the deduction of individual payments. And I do think that discretion is important in a bill like this. The kind of discretion, though, that Sue Moroney has referred to, I think it's only fair that she seek clarification on that matter. I have to admit that I'm dragging back into the recesses of my mind. I remember the debates that were had around new families, where new families are formed by liable parents in particular. What then is their responsibility on an ongoing basis to their new family versus their existing biological family, no matter how many years of separation, or, importantly, the amount of income that is brought into the home by a new parent, where the non-liable parent is no longer in their place. I think what was an important principle discussed by the Select Committee, though, was regardless of whether or not a custodial parent repartners with someone with all the wealth in the world, it is still ultimately the responsibility of a biological parent to contribute to the upbringing of their child. And I think that is a principle we should stand absolutely firm on. Now, that means that even if a mother repartners with a very well-to-do individual, or a father repartners in that same kind of scenario, it doesn't matter which gender, it doesn't matter who is the liable parent or the custodial parent. The principle is that the responsibility follows the biological parents wherever they may be, and the calculation applies to those parents. And I think that's right and fair regardless of how many years they have been in separation. And that is certainly what I think this House would intend to be on record, that when it comes to discretionary provisions, that is our intent, that the responsibility lies with those parties. But when it comes to the deduction regime, there is some importance to a certain degree of discretion, particularly, and one of the things I remember discussing was when you're involving individuals who do have limited income. They might be beneficiaries, including a non-custodial, a liable parent might be a beneficiary. We do need to take into account the ability to factor in their income levels, and if automatic deductions would cause someone to dip below what would be considered a fair and reasonable ability to financially survive. One of the points we also wanted to make, though, with the change of the regime so that it's an opt-out system, because, of course, until now, automatic deductions from employees' wages have only been permitted on an opt-in basis, and we're reversing that onus now. That is quite a significant change. That means that Inland Revenue's guidelines for notifying liable parents of intent to disclose personal information to an employer had not yet been developed, is my understanding. But it's our view that if we apply natural justice to the situation, liable parents should, of course, have the ability to object to the disclosure of information. Now, we've had examples before the Select Committee, which we heard and agreed with, that said under certain circumstances you wouldn't necessarily want your employer being aware of a deduction for a child that they may not even know that you have. And that is up to that individual's own conscience over how they manage that. So we wanted to take into account the ability of discretion there. But we haven't really thought more broadly about whether or not this automatic deduction regime does allow, Mr Chair,
Jacinda Ardern.
does allow discretion in other circumstances. And equally, there is certainly going to be examples where there will be potential unfortunate and unjust disclosures of personal information by the state, because we've seen them in the past. Inappropriate disclosures by the state, unfortunately, have become quite a common occurrence. The state has proven itself, be it work and income, be it ACC, to be a poor manager of people's individual information. And what protections will we have in place to ensure that this information, the opt-out regime, is dealt with with the due care that it needs to be? And that's something that I would put to the Minister, that if he at some point were able to speak to some of these concerns, then that would be worthwhile, I think, to the House. But one of the other concerns we also raised, though, is that when it comes to employers, they will be bearing the brunt of the administrative cost over this now opt-out regime. And this was something we wanted to flag, particularly where small business owners might be impacted by a deduction regime. There didn't seem to be any regulatory impact assessment of what cost small businesses or large businesses would incur through deduction policies like this, and I would have been really interested to see what impact that would have. But I also want to point out, Mr Chair, that when it comes to things like deduction regimes, when it comes to debt reduction, which is another significant part of this bill, and the idea of trying to reduce down penalties, for us the principle that we were relying on is, what can we do to ensure that on an ongoing basis we try and encourage more parents to ensure payment of their fulfilment of their responsibilities under this Act? Now, if we have evidence to suggest that actually the high burden of debt that an individual might be carrying might be reducing the likelihood of them coming back into the system and doing what is right and paying their way, then we should look at how to reduce that down. That is a reasonable thing to do, and certainly we accept that. Judith Collins, however, did not seem to accept that, and I think it's only fair that we point out that in 2005, in her ongoing way of taking an approach that seems to be purely punitive without taking into account the evidence base or what impact it might have on the child, said writing off debt sends the worst possible message to absent liable parents. The government is telling them if they dodge their responsibilities for long enough, they will get a discount. That is the wrong message to send. We know the evidence actually says otherwise, and that actually it's penalty payments that seem to be accruing in a lot of cases, and that if we can do something to ensure that we engage parents back into the regime, then that's what we should be doing, whilst of course making them responsible. But in 2007, Judith Collins went further than that. She wanted to ensure that action was being taken against parents who default on their child support payments at the border. And I have to say, if we're picking up traffic infringements at the border, why aren't we picking up non-paid child support payments? In 2008, in fact, Collins supported making avoiding child support an arrestable offence. Where is it now? Where is it now? Where is that hard line now, then, that the government wants to take on parents who aren't paying their way? It was easy in opposition, wasn't it, to say, make all of those statements? Well, where are the provisions now? Because only just within the past 3 weeks, I've had a case of an individual from Australia who has not been paying their way. They're in New Zealand, and we know where they are, and what is IRD doing? Unfortunately, very little, and that must be enormously frustrating for the individuals in this case who aren't even biological parents, but who just want the parent of this child to do the right thing and pay their way. Now, if IRD had come to the government and said, we think we need these powers, then I would hope that the government would act. Well, now we're saying that there's a case for the government to be looking into these powers, and Judith Collins seemed to see it before, and why it suddenly escaped your view, but instead the government seems happy to be focusing in on welfare fraud, where we already invest $39 million chasing that each and every single year. Well, what about investing a little bit more in chasing some of the debt that's being taken away from our kids as well? And I would ask the Minister, if that was explored, I'd be quite interested to hear the rationale for why it was not a part of this bill.
Mr Chairman.
Todd McLeod.
The question be now put.
Dr. Rajan Prasad.
Thank you, Mr. Chairman. It's just a